Good morning. Today is Tuesday, May the 28th, and we are back for another Tuesday tip. For those of you who are new here, welcome. My name is Pia Miller. I'm an attorney in Virginia, own my own law firm. All the contact information is below. And every Tuesday I come in and talk about a little something random. And if you've been paying attention these last few weeks, been addressing some frequently asked questions that come up a lot during consultations, just a lot in my day-to-day life as an attorney. One of the things that has recently been in the news, but also ties into some of my recent FAQs. Don't know if you guys saw, but in Missouri, I believe, there were some headlines floating around a month or so ago about how pregnant women were not allowed to be divorced, or like you could not get your divorce finalized if you were in fact pregnant. I'm not sure if that was actually the case. I've seen some other articles that came out that said, that wasn't quite what the state of the law was in Missouri. But what I want to point out to you is that that's kind of a thing as well here in Virginia. Pia, why are the courts in my business? Why do they care whether or not I'm pregnant? Okay, so let's talk about it. So legally in Virginia, when a child is conceived or born during a marriage, that child is automatically presumed to be biologically of the marriage. So the husband is presumed to be the father. If he is in fact not the father, and perhaps that is the reason why the two of you are looking at getting a divorce, perfectly fine. I don't care. I'm not here to judge. But there's a whole other legal proceeding that has to occur because legally the husband is presumed to be the father. You have to essentially disestablish paternity, establish paternity, get the other, biological parent in here. They have to then do a whole bunch of things, right? And the other legal requirement, as it relates to the actual divorce, is that any issues regarding custody, visitation, child support, all of those issues have to be addressed during divorce by the court. So as we do the adult-related things, i.e., dividing up cars and houses and retirement accounts and bank accounts and things like that, we also have to do the child-related things. So if there's a child on the way, we can't do custody, visitation, and support, or we have to address those things while the child is on the way. And so what happens logistically is that in the actual divorce complaint and in the final order of divorce, it's going to say, A and B were married on this date, they separated on this date, and 2 children were born of the marriage, to wit, XYZ and XYZ born on these dates, and no children were adopted, and wife is not currently pregnant from the marriage and is not expecting any further children from the marriage. Like, we literally have to say this in our divorce documents. Courts will kick back our pleadings if they do not have this information. So again, I appreciate if there are extramarital situations. That happens. That is part of life. But do realize that if that is your situation, it's not just as simple as, oh, we're just not going to mention it. Oh, we're just going to glaze over it. Oh, it's not an issue. The courts will never know. No. Like, it will literally hold up your divorce. So this is not the time to try to represent yourself. You need to try to do things properly. You definitely need to talk to an attorney if this situation applies to you. As always, if y'all have questions, don't hesitate to reach out. Take care of yourselves, drink your water. It's getting hot out here. Come back next week for our next Tuesday tip. All right, guys.